Thank you for joining us. Today we're joined by Myriam Roccatello from New York, who is the Deputy Executive Director and Director of Programs at the International Center for Transitional Justice. Ms. Roccatello has over 25 years of experience in the rule of law, human rights, and transitional justice. Ms. Roccatello, thank you very much for joining us.
Thank you very much for having me.
So, what are the main provisions of drafting a constitution, given the transitional stage that Armenian democracy is in? In other words, how can one draft a constitution which is not just a legal text, but a social contract for society?
Right. I think you have pointed out that the crux of the matter. The Constitution is indeed a legal document, but it contains the principles that are supposed to govern the country and the relationship between institutions and citizens and among citizens for now until the end of time. It should be sufficiently broad and flexible based on principles to adapt to social and political and legal developments that may occur over time. Now, in a moment of transition, the drafting of a new constitution, when felt necessary, is particularly critical because, on one hand, we need to consider what were the shortcomings that have generated a deviance or a disruption of the society and the institutional setting, and have undermined, therefore, the role and the dignity of the citizens that institutions are deputed to serve. But on the other hand, we also need to stick to principle measures rather than over-detailing in the provisions the regulation of certain aspects of the institutional and legal framework, which may then cause problems later on because the situation may change, because other issues may occur. And the other advantage of having a principle constitution is that the constitution itself doesn't solve all the problems. In order to have a real democratic transition, you need a cultural, legal understanding of guarantees and protection. So if you, at the same time, you have to foster and promote a culture of right-based approach, a culture of legality and guarantees, a culture of democratic understanding of the social contract. So I cannot tell you what exactly the provisions may be because these vary from country to country. There are indeed some countries that during or after the transition have opted for particularly long, detailed constitutions that basically included every single problem that they wanted, that occurred during originated the conflict or the democratic deficit. But that is not in principle the solution. Armenia, in addition, comes, although has a troubled past, but is inserted in a culture, in a European-inspired culture. Is a member of the Council of Europe. There are elements here that should be fostered rather than encapsulated in provisions themselves.
Does drafting a constitution have an effective instrumentation, have a role in effective instrumentation of judicial and institutional reforms as well as transitional justice mechanisms?
It does indeed. When it comes, and I would start with the transitional justice aspect. What is not always understood is that when a country opts to transition and to apply transitional justice processes, the Constitution is often considered separate, right? And there is a very problematic lack of understanding that actually being the Constitution, as you said at the beginning, the basis of the social contract, it cannot be divested from a transitional justice process. It's actually the core of where you reset reset the basis for the future. Therefore, a big role for the Constitution to sustain, to be the engine of the transition. And then you may decide whether in the Constitution you want to include the provisions of transitional justice measures to protect, to ensure their implementations, or not. Transitional justice measures per se are not meant to stay forever. So a good rule of thumb is to ensure that maybe in the constitutions you have very strong principles that are at the basis of those measures, and therefore they can be referred to when the transitional justice measures are threatened politically or socially, but they're not necessarily included in the Constitution. One example that I often bring in these when I discuss this topic is Kenya. The Kenyan Constitution, for example, included transitional justice measures, but as an annex of the Constitution, and with the recognition that in any event Kenya belongs to that category of countries that has opted for a pretty lengthy, detailed constitution, which is not always, as I mentioned before, the usual paradigm of constitutional revision. When it comes to judicial institutions, these are one of the core of a constitution because it's the third branch of government, as we say. And therefore, if there is something that has to be provided for in the Constitution, is certainly the independence of the judiciary, the basic principles on how the judiciary is protected and can operate vis-a-vis the government and the parliament, and the mechanisms that make, the constitutional mechanisms that make that independence effective. So the protection, the appointment of judges and prosecutors, the power and authority of the judiciary to scrutinize the actions and operation of the other two branches, the limitation of that power, and so on.
So what are the main legal, political, and governance issues to conduct a constitutional review process, and how can Armenia avoid scenarios that have been seen in countries like Ukraine and also Latin American countries?
But I would say, well, Latin America is a big basket, so I'm not sure that, I wouldn't consider all the countries in Latin America problematic from a constitution point of view. Whether we consider Colombia, for example, as truly part of Latin America, Colombia has a constitutional tradition that is very, very strong. And so, it's not all of them are problematic. What I would say is that the revision of constitution goes beyond a legal drafting. And I perfectly recognize, particularly in a post-breakdown situation, when there is this momentum, this strong will for change, that there is a rush to change the basis, so the constitution. However, we need really to avoid that results in a drafting legal only technical process, because if you want the constitution to become the basis of the transition, the change, and you want the constitution to be considered and perceived by the citizens as the ultimate frame of guarantees of their own role vis-a-vis the collective, you need to enlarge the basis of discussion. So that's why the successful constitutions have normally come out of what we call a constitutional assembly, which is a committee, a body that is mandated to discuss politically and socially how the constitution would look like to represent correctly the values of the new country the population wishes to have. And normally this assembly is composed not only by politicians, but by eminent representatives of the society, as representatives as possible, that have the legitimacy, that have the credibility. So they may have a political affiliation, for example, but they are recognized because of their integrity and because of their professionalism and their commitment to the country at large. So in that setting, then you can at the same time discuss and consider the different principles, and then normally this assembly is assisted by a technical committee that starts imagining how those principles can be codified.
Recent developments around the Armenian Constitutional Court have raised many questions for Armenian society. How would you assess these processes from an international experience perspective?
Look, it's very difficult to make a comparison. I would say that indeed the issue of the composition of the Constitutional Court, which I think it's one of the issues you referred to, if I understood correctly, and the debates around it are very specific to Armenia. One, you cannot have a constitution without a strong constitutional review process that is based, that can only apply if you have a constitutional court and a strong constitutionalism culture. The culture that the Constitution ultimately is the reference to ensure that even the best drafted laws cannot be applied or interpreted against the principles that you inserted in the Constitution. That is the main role of a constitutional court, beside, obviously, the very critical role of resolving potential constitutional crises when they occur, right? So it's difficult for Armenia to have a new culture of constitutionalism and respect for rights and guarantees if the Constitutional Court includes representatives that are associated with an historical period that is perceived by the larger society as abusive. Right? I absolutely do not have any ground, and it's far from me from entering into personalities or the profile of the current constitutional judges. I'm just saying that from an external point of view, I perfectly understand the need to have a constitutional court that is believed to be strong, to be impartial, to be the guarantor of a constitution. And therefore, the composition is very important. Now, how can you change the composition of the court while at the same time you are working on the constitution? It's a bit of a catch-22 type of situation, because in order to enact the changes, you need a constitutional court. If you don't trust the constitutional court, or the constitutional court is deficient, even the best effort to change the constitution may be frustrated by judgments of the Constitutional Court that are not in line with the spirit of what you want to achieve. So this is all to say that the attempt to have a Constitutional Court which is composed of judges who inspire that trust, that are perceived as representative of the new spirit of the new Armenia, is perfectly understandable. And therefore, the idea of a referendum, or as it was in the past, or to change some members, is not far-fetched. It's quite natural. How, however, that is affected, and how the problems, the implications that these decisions trigger in Armenia is also understandable, because the individuals that will be targeted by these measures have a legal right to at least challenge decisions that affect their positions and their rights. So it's all a matter, it's inevitable that you enter into these problems. what could have been done. A new constitution could have established a different constitutional court or a renewed constitutional court, and you could have restarted, a process of appointment, nomination, and appointment after the entry into force of a new constitution. But that, again, as I said before, leaves you in the problem of having to redo the constitution while having a present operating constitutional court which is not in line with the changes. So the per se is not, even from a comparative law point of view, it's not, it's understood that some measures had to be taken. But this doesn't, and there are not really many solutions to avoid, however, the implication and the legal recourses or actions that may come out, and the political debate, more importantly, because these constitutional judges are perceived to come from a different era and therefore represent a different spirit.
And finally, what are the prerequisites and mechanisms of drafting constitutional reforms to ensure inclusive and effective participation of a larger strata of society, including the active participation of civil society and also the youth?
Right. Look, the principle is what you mentioned, to try and ensure the largest participation possible, because the Constitution is the legal framework for everyone. And it's not only a matter of giving everyone a voice, it's also a matter of transmitting the message that this Constitution must be owned by everyone, that some may not be fully in agreement with the individual provisions, but the principles and the main structure of the Constitution, but they still recognize it as a good basis to live collectively in the state of Armenia. You see what I mean? So how do you ensure participation? There are a variety of different measures. For a country of the size and population of Armenia, it's not unthinkable to imagine a wide consultations that is decentralized, that tries really to have discussions at the more micro level, because at the end of the day, it would be technically possible. You can organize and you can really rely in that sense on civil society organizations that may have a presence in various parts of the country. You may rely on political parties, of course, that have branches and presence in the what we call the field, but the non-capital basis. As long as you include the different voices and you have transparent discussions. What is even more important, however, is that these consultations are not just for the sake of consulting. You need to put together a process, a transparent process, where you give account of what was said, how it was translated in a process of decision making, what were the decisions ultimately that brought to that provision vis-a-vis the other, because in consulting, and this is something that very often is not clearly understood, you instill the expectations that what is said will then be reflected necessarily. And instead, there are political, social, and legal technical issues that whereby certain instances may not be immediately reflected or may be differently reflected than what the base asks for. So the process is really what is very important is first designing a process of consultations that is as representative as possible, but also to put in place a mechanism where there is communication and transparency on what has been said during the consultations, how these instances have been considered, and what is ultimate result and why. why that provision looks like that, what are the implications, what are, these are all, there are specific documents that accompany a constitution. You can imagine even an explanatory note. You can certainly have public debates where media is critical, So just a few words about youth. Youth has become a little bit the betting horse of ICTJ. Why? And that's why we bring it up, and we always underline the importance of youth. But why? Because as an organization that does transitional justice for a living, we realize, particularly in those countries where the political resistance to transition is very high, that youth remains an agent for change. And more importantly, youth is the generation that will need to carry out the changes that are imported in the Constitution. So by including them, it's not only a matter of ensuring that your consultations are sufficiently representative, it's also a matter to form and groom and make grow a generation that will have a political role. It is a manner of fostering and improving a civic responsibility of the citizens, of the new generation of citizens, vis-a-vis a legal framework that, as I said, can be perfect, but can still be applied, perversely. So that culture of democracy, diversity, pluralism, respect for rights has to come somewhere. And it is a combination between the old generation of technically very prepared, legal experts and politologists that have a role to play because they have the experience, because they have experienced firsthand repression or abuses, with the instances of change and the look forward that youth brings.
Ms. Roccatello, thank you very much for your time.
Thank you very much. It's always a pleasure to speak to you, and good luck with that.
Thank you. And thank you for joining us on CivilNet.